I could not really understand about the directors and their duties. Could you help me to explain about this?
Oh, really? But I don't think so it is difficult for you to understand. Let me show you a video about the director and their duties along with a related case sample.
In this video, we are going to briefly explain the duties of director in a company. First, what is a director according to the Companies Act 2016? Section 2 of Companies Act 2016 defines director as any person occupying the position of director of a corporation by whatever name called, and include a person in accordance with whose directives or instructions the majority of directors of a corporation are accustomed to act, and an alternate or substitute director. According to Section 196, a company shall have a minimum number of one director in the case of a private company and two directors in the case of a public company. The appointed director shall be a natural person who is at least 18 years of age. Under Section 198 of Companies Act 2016 state that a person may not hold the position of director of a company, or if he is directly or indirectly related or participate in the management of a company, if the person have the following criteria. The first criteria is if the person is an undischarged bankrupt. The second criteria is if the person has been convicted of an offense relating to the promotion, formation or management of corporation. The third criteria is if the person has been convicted of an offense involving fraud, dishonesty and bribery. If any person who contravenes this section commits an offense and shall on conviction be liable to imprisonment for a term not exceeding 5 years or to a fine not exceeding 1 million ringgit or both.
Let's look at appointment of directors. Under Section 202 of Company Act 2016, the Board of Directors may at any time appoint a director in addition to the existing director. The directors so appointed shall hold office in the case of public company until the next annual general meeting, and in the case of private company with accordance of terms of appointment. All subsequent directors may be appointed by ordinary resolution passed by a simple majority of votes. The power of the director is to manage the business and affairs of the company. Under Section 211 of Company Act 2016, the business and the affairs of the company should be managed by or under the direction of the board. The board has all powers necessary for managing, directing and supervising the business and affairs of the company, subject to any modification, exception or limitation contained in this Act and in the Constitution of the company. Here are some examples of powers of directors. The director can enter into any contract on behalf of the company, purchase or acquire another company and sell the company. It can be inferred that the directors granted huge power to manage a company. However, the huge power granted would lead to abuse of powers by the directors. Thus, laws has been created several director duties complied by the directors to prevent abuse of powers.
A director is an officer of a company. He is also an agent of the company, and the company, being a principal, is bound by the acts of its agents. Thus, when exercising his powers, a director owes a fiduciary duty towards the company. Here are some of the important roles and responsibilities of a director of a company. A director must at all times exercise his powers in accordance with the Act for a proper purpose and in good faith in the best interest of the company. When exercising his duties, a director must only consider the interests of the company and nobody else, not even his personal interest or the shareholders' interest. For example, when issuing new shares, the director must exercise the power for a proper purpose. In example, to increase the company's capital for the purpose of financing its business. The power cannot be exercised for the purpose of diluting the voting power of existing shareholders. Oh. A director must not use the property of the company, use any information acquired by the virtue of his position as a director of the company, use his position such as director of officer, use any opportunity of the company which he had become aware of in the performance of his functions as a director or officer at the company, or engage in business which is competition with the company, to gain directly or indirectly a benefit or profit for himself or any other person, or cause detriment to the company without the consent of the board or ratification passed in the general meeting. A director who has an interest in transaction with the company may be in conflict with his fiduciary duty as a director, is required to declare the fact and the extent of his conflict at the board meeting at his earliest opportunity, and he should abstain from the voting process.
A director must exercise reasonable care, skill, and diligence with the knowledge, skill, and experience which may reasonably be expected of a director has same responsibilities. A director also ensures that all his decisions that he makes are of highest standards and in the best interest of the company. Such duties applies whether a director is an executive or non-executive, and it also extends to the senior management staffs such as CEO, CFO, COO, and etc.
The plaintiff and two others set up the defendant company, where each of them has equal shares. All three of them became directors, but only the plaintiff was responsible for the day-to-day operation of the defendant company. In October 2013, it was discovered that the plaintiff had set up a branch of the defendant named as Taman Yal branch. On 18th March 2014, the plaintiff resigned from the defendant company, due to the rise of conflict about the Taman Yal branch. Before the plaintiff left the defendant company, she had recovered a sum of 33,676 ringgit 20 cents from the cash proceeds, leaving a balance of 145,214 ringgit 1 cent, which was allegedly advanced by her as a loan to the defendant company. However, the defendant opposed that the plaintiff did not disclose nor obtain approval of the two other directors for the so-called advances and the opening of the Taman Yal branch. Besides, the plaintiff allegedly had utilized funds from the defendant company and has personally entered into an agreement with an investor named David. Under the agreement, where David would provide a sum of 150,000 ringgit as investment and be given a 15% of the shareholding of the defendant. The defendant company was loosely run as there were no proper board meetings or resolutions formally passed and no ledger was maintained since its inception. Therefore, the management and finance were left to the plaintiff, who was a self-appointed CEO and managing director that operated the company as if it was her own.
There are some sections under Companies Act 2016 that we found to be related to this case. Firstly, Section 213 subsection 1. A director of a company shall at all times exercise his powers in accordance with this act for a proper purpose and in good faith in the best interest of the company. Section 218 subsection 1 subsection C and subsection D stated that a director or officer of a company shall not, without the consent or ratification of a general meeting, subsection C stated, use his position as such director or officer. Subsection D stated that use any opportunity of the company he became aware of in the performance of his functions as the director or officer of the company. From our point of view, we can say that the plaintiff did not comply with the both sections mentioned previously, which are Section 213 subsection 1 and Section 218 subsection 1, subsection C and subsection D. Why it is said so? This is because, based on the case, we know that the plaintiff Yong Mei King as the director was a self-appointed CEO and managing director. Moreover, she operated the company as if it was her own to gain directly or indirectly a benefit or profit for herself. Besides, she also entered into an agreement with David, who was an investor, and gave 15% of the shareholding of the company without the consent of the board or ratification passed in a general meeting. Furthermore, the plaintiff set up a branch of a company called Tamayal without the knowledge of other directors of the company. This shows that the plaintiff did not exercise her power as director for a proper purpose and in good faith in the best interest of the company. At the same time, she misused her power as a director. Hence, we can say the plaintiff did not comply with the both sections mentioned previously, which are Section 213 subsection 1 and Section 218 subsection 1, subsection C and subsection D.
The court decision was the plaintiff failed to prove that she had made advances to the defendant company. because the documents that showed as evidence were not verified and uncorroborated as it was prepared by herself. Besides, plaintiff did not produce an audited or verified statement of accounts of the defendant company. Furthermore, there is no evidence of enticement on the part of plaintiff. Hence, the defendant is not entitled to be reimbursed or compensated by the plaintiff.
For the penalty, according to Companies Act 2016, if the court found breach of fiduciary duties by the director will be liable to imprisonment for a term not exceeding 5 years or to be fined of not exceeding 3 million or both under Section 213 subsection 3 and Section 218 subsection 2.
Therefore, directors make strategic and operational decisions of the company,
And the directors are responsible for ensuring the company meets its statutory obligation.
A company director is required to operate honestly and lawfully and make verdicts for the good of the company as well as their members.
The future of the company and businesses is now in the hands of director of the company.
Since they are conferred with wide management powers, the law sets a limit to curb any mismanagement of a company. Okay guys, that's it from us. Let me end this video with a